This video will take you step by step through a flowchart on the topic of assignment of property rights. It is designed to assist your understanding of the rules for the transfer of property at law and in equity. It is also relevant to the constitution of trusts, as the question of constitution is answered by reference to the same property transfer rules. The first issue to consider is whether the thing sought to be transferred is property. It is not possible to assign mere personal rights, and any attempt to assign or transfer a mere personal right will fail. An example of a mere personal right is a right of access over land. A personal right of access over land cannot be transferred. By contrast, valid types of present property which can be transferred include land, chattels, shares, intellectual property, bills of exchange and cheques, debts or other legal shows as in action, and equitable interests such as partnership interests. If you are satisfied that property is involved, the next issue is whether the transferor has a present property right or only a future property right. Property is future property either because it does not yet exist, or, although it exists, it is not yet owned by the person assigning it. For example, a purchaser might like to order a car that has not yet been built. Future property cannot be assigned at law, whether the transaction is for value or not. Equity will assist, but only if the transaction is for value. If the purchaser pays for the future property right, for example by paying a deposit, then equity will force the car dealer to transfer it to the purchaser when it comes into its hands. If consideration is given, a future property right can be transferred. Any attempt to give the right away for no value, for example as a gift, will fail. Once you have determined that the property is presently existing, the next question is whether value has been given for its transfer. If so, the common law or equity will enforce the transaction. We will concentrate on the cases where no value has been given, where the transaction involves a gift. When determining whether the assignor has successfully given the property to the assignee, different rules apply, depending on whether the property is characterized as legal or equitable. The next question then is what sort of property is involved. Is it legal property? Legal property includes land, chattels, shares, cash, bills of exchange, debts, and legal shows as in action. Most legal property is able to be assigned at common law. Common law will recognize the transfer if the transferor has complied with the transfer rules applicable to that sort of property. Different types of legal property have different transfer rules. This flowchart does not cover the detail of each transfer method, but these are outlined in your text and in class. The transfer method that is used must be the correct method for that type of property. If the relevant legal assignment rules have been complied with, the assignment of the property will be complete at law. Remember also that if land is involved, the extra statutory requirements for Section 53(1) of the Property Law Act also need to be satisfied. The signed transfer, or a deed in the case of general law land, will satisfy Section 53(1). If the appropriate legal transfer rules have been completed, property in the thing has passed at law to the transferee. But what if the transfer is not complete at law because the relevant transfer rules have not been fully satisfied? Although the law cannot recognize the transfer, equity will still recognize it if the donor has done all that the donor alone can do. It may also be necessary that the donor put the property beyond his or her recall. Usually, the donor will have done all that the donor alone can do if the donee has been put in the position to complete the transfer him or herself. If the donor has done all that he or she needs to do, there will be an equitable assignment of legal property. Remember also that Section 53(1) of the Property Law Act still needs to be complied with if the property is land. This will be satisfied if there is a signed document. Sometimes legal property is not able to be assigned at law. A part of a legal shows in action cannot be assigned. This is because Section 134 of the Property Law Act only deals with whole choses, and the law does not recognise assignments of intangibles apart from statute. Therefore, if you want to give a gift of a part legal chose, it will not be effective at law, but it might still be effective at equity. For this, the same transfer rules apply as for equitable property. What equity requires is that the transferor show a manifest intention to immediately assign the part chose. If that intention is clear, equity will recognise the transfer and the part chose has been transferred in equity. Now, let's look at equitable property. This is property which is only recognised by a court in its equitable jurisdiction. Equitable property includes a vested interest in a trust, a partnership interest, or an equitable interest in land, for example, an equitable mortgage. Equity does not require the formal transfer procedures found at common law. All equity asks is that the donor had a manifest intention to immediately assign the property. There is dicta to the effect that the best way to demonstrate manifest intention is to execute a deed. Some statutory requirements apply in addition to equity's requirements. First, for the assignment of equitable interests, Section 53(1)(c) of the Property Law Act must be satisfied. A disposition of an existing equitable interest must be in writing, signed by the donor. This applies to equitable interests in personal property as well as land. Note also that dicta in the High Court case of Federal Commissioner of Taxation and Everett suggests that Section 134 applies to assignments of absolute equitable choses in action. It is likely that the use of Section 134 for these assignments is an optional alternative rather than mandatory, and it may not be discussed in your lectures. So, in summary, you need to be able to do three things. 1. Correctly characterise the property. 2. Identify if the property is assignable. If so, you must apply the appropriate transfer rules at common law or in equity. 3. Reach a conclusion whether the transfer is complete at law or in equity, or whether the transfer fails completely.